Welcome to our discussion on your rights as a parent in Washington State Dependency Court. We'll explore Revised Code of Washington 1334 to 110, your right to refuse to sign, and the legal boundaries of the Department of Children, Youth, and Families. Every statement except for those made by corrupt judges was generated from AI.
We don't give a shit if they sign the order. We just ignore them and force them to have attorneys. The attorney will sign for them. I have immunity. That's amazing.
A dependency fact-finding hearing under RCW 1334.110 is where the court decides if a child is dependent. This is crucial, as your agreement and signature on court orders are significant. The law mandates meaningful parental involvement before proceeding. I am going to say that one more time for the employees at the Superior Court of King County. The law mandates meaningful parental involvement before proceeding.
They don't have to sign. See, look what I am wearing. They already think I have power. I decide everything.
Your signature in the dependency process is crucial under RCW 13.34.110. It signifies legal agreement and carries significant consequences. Never sign without full understanding or agreement, as this decision holds strong legal implications. Under RCW 1334.110, the court requires parental agreement. Parents should never feel pressured into signing something they do not understand or agree with. And there are strong legal reasons to carefully consider whether to sign at all. The court cannot replace a parent with an unknown parent, as it lacks legal standing. Doing so could be considered fraud, undermining judicial integrity. Moreover, bypassing a present parent's participation may violate their constitutional due process rights, which include being heard and making informed decisions about their children. There is no language anywhere in RCW 1334.110 or in Washington State dependency law broadly that authorizes DCYF to force a parent to comply with services or to force a parent to sign a dependency court order. The law simply does not grant DCYF that authority. Parents need to know this clearly and directly.
What are they going to do if they know that? Stop us? Right. That has never happened. We are way too powerful for that.
The Department of Children, Youth, and Families, as a state agency, can recommend and offer services, but lacks the legal authority to compel a parent to participate in juvenile dependency proceedings. In juvenile dependency proceedings, parents are not defendants. This civil process focuses on the child's welfare, not criminal prosecution. Legal standards and procedures differ significantly from criminal court. Coercive tools like criminal penalties don't apply. Participation relies on parental agreement, with no legal mechanism for forced involvement if a parent refuses to participate. The entire framework of juvenile dependency in Washington only provides options where parents agree. There is no built-in legal mechanism for what happens when a present identified parent simply refuses to participate, because the law did not design for forced participation. Signing a dependency court order without intending to comply can harm you. It signifies agreement, and non-compliance may lead to termination of parental rights. If unable to meet the order's requirements, not signing might be safer. Always understand the consequences before signing under pressure. A parent present in court who declines to sign a dependency order is exercising a lawful right. Department of Children, Youth, and Families cannot override this refusal or force agreement. Genuine participation is required. Consent cannot be manufactured. A present parent must be recognized by the court. Document any such occurrences and consult a family law attorney. Your due process rights include being present, heard, making informed decisions, refusing services without penalty, and challenging violations. The law offers options, not mandates. When parents agree, there's a clear path for services and reunification. However, if parents disagree, the law lacks a mechanism to force compliance. Washington's revised Code of Washington 1334 framework relies on parental cooperation, and Department of Children, Youth, and Families cannot proceed without agreement from a present identified parent. Your signature is a legal act. Never sign without understanding the consequences. Department of Children, Youth, and Families cannot force you to sign a dependency order under Revised Code of Washington 1334-1110. Courts cannot replace a present parent with unknown parent without risking fraud. You're not a defendant in juvenile court. Consult a Washington state attorney to protect your rights.
Welcome to our discussion on Washington's child removal laws. We'll explore concerns raised about the Department of Children, Youth, and Families' handling of dependency and termination proceedings, focusing on potential misapplication of key statutes. This video was generated by artificial intelligence, which in this case is more reliable than your average attorney in the state of Washington. Washington's legal framework involves two key statutes, RCW 13.34 and RCW 26.44. RCW 13.34 is intended for cases of child abandonment, while RCW 26.44 addresses abuse and neglect. Parents argue that the Department of Children, Youth, and Families misapplies RCW 13.34 in situations involving present parents, using a statute meant for abandonment inappropriately. Under RCW 13.34.30401, a dependency petition can only be filed if a child has been abandoned for at least 3 months prior to filing. Parents point out several immediate problems with how DCYF applies this standard in practice. If a parent is actively present, the child cannot legally be abandoned. The statute contemplates a child with no parent, not a child whose parent DCYF disapproves of. A newborn cannot have been abandoned for 3 months. They haven't been alive that long. Yet DCYF removes newborns, which parents argue is unlawful on its face under the plain text of the statute. One of the most technical but significant arguments parents raise centers on the precise legal meaning of custody terms across different statutes. The distinction matters enormously. Taking a child into custody, as contemplated by RCW 13.34, implies receiving an abandoned child from no one, while seizing physical custody from a present parent requires the protections of RCW 26.21, including a proper warrant. Parents argue DCYF routinely skips this step entirely. RCW 26.21, the Uniform Child Custody Act, explicitly defines both physical custody and warrant. Parents argue this is the governing statute when the state seeks to take physical custody from a present parent, because it contains the procedural safeguards that action requires. However, RCW 13.34 contains no mention of warrants. This, parents contend, is not an oversight. It's evidence that RCW 13.34 was never designed to apply to situations where a parent is present. You don't need a warrant to pick up an abandoned child. You do need one to take a child from their parent. Washington law does not expressly authorize a termination trial. Under the principle that courts can only exercise powers explicitly granted by statute, this is more than a technicality. RCW 13.34.200. The statute describes a termination order as final. Parents argue that if termination were meant to be contested at trial, there would need to be appeal rights. But a final order, by definition, has none. The legal logic: if there is no authorized appeal from termination, then there was no trial in the first place. A trial without appeal rights is not how adversarial proceedings work in American law. In juvenile court, parents hold no defendant status. Subjecting a non-defendant to a termination trial about custody is conceptually improper and without statutory basis. Under RCW 13.34.110, The statute assumes their agreement, not contestation, in dependency cases. This suggests the framework was meant for consensual situations, not adversarial ones. If true, contested hearings may exceed legislative intent, raising due process concerns about binding parents to a process not designed for opposition. If the statute 13.34 only contemplates parental agreement, then every case where a parent objects and contests the dependency may be proceeding outside the statute's scope entirely. Courts holding contested dependency hearings under RCW 13.34 may be doing something the legislature never authorized. RCW 13.34.03006 defines dependency, but interpretation varies. It should be read as a whole, not by individual subsections. RCW 13.34.130 reaffirms this, stating that the child be defined as dependent according to the entire section 13.34.030. Judges inserting an implied "or" between subsections A, B, C, and D are seen as adding words not present in the statute, which courts are generally prohibited from doing. RCW 13.34.130 requires defining child under RCW 13.34.030 inches as a whole, not by picking individual subsections. Judges who insert an implied "or" between A, B, C, and D are, in this view, adding words to the statute that the legislature never wrote, a practice courts are generally forbidden from doing. The statute says what it says. Courts cannot rewrite it through interpretation. Here is the form that DCYF uses to remove children from their parents. As you can see, there is an "or" after the second option. You can find this form under Dependency Petition at courts.wa.gov, where all of their mandatory court forms are located for the state of Washington. As you can see here, there is no "or" after option B. The "or" does not come until after option D. So the Supreme Court judges and the committee, which is who creates these court forms, added the word "or" to these laws. That's not in the actual law. Washington state courts use standardized forms that parents argue effectively amend statutes without legislative action. This raises separation of powers concerns, as only the legislature can amend laws. The form's statewide use means any judicial overreach affects thousands of families, with no legislative approval or public vote involved in their creation. Only the Washington state legislature can write or amend statutes. When a court form adds a checkbox, an "or an implied procedure not found in the RCW, judges are arguably exercising legislative power they do not constitutionally possess. The Blake decision challenges the Department of Children, Youth, and Families' reliance on parental substance abuse for child removal. The 2021 ruling invalidated past drug possession convictions, raising constitutional issues when such evidence is used to terminate parental rights. If drug possession is no longer a legal wrong, using it as grounds for separation is problematic. The Washington State Supreme Court legalized drugs possession, right? They did it retroactively. That means that for the past 20 years prior to 2022, when they legalized it, everybody's charges was dropped and people were paid back their fines and everything. But none of those parents who lost their kids during that time for the same exact reason were compensated in any way for the child support they paid while their children were taken from them or anything, even though technically that is also, possession of drugs, and they weren't even charged with the crime. They were just accused of being on drugs, and their children were permanently separated and their rights were terminated, and they didn't get any compensation for that. Parents report being pressured by the Department of Children, Youth, and Families to sign dependency orders, fearing they'll lose their child otherwise. This is seen as coerced abandonment, with significant legal implications. Under the Revised Code of Washington, 13.34, signing may be interpreted as voluntary abandonment, stripping protections. These parents weren't informed, making consent invalid. RCW 13.34 lacks reunification statutes, focusing instead on separation. The absence of provisions for a child's return home, arguing the statute assumes permanent placement for abandoned children. The term child's home suggests independence, not temporary separation from parents. This absence is not accidental, parents argue. A statute designed for abandoned children with no parent has no need for reunification planning because there is no parent to reunite with. The entire statutory architecture assumes the child is alone and needs permanent placement, not temporary intervention. In Washington, dependency cases, the child's name is used, not state versus parent. This signifies the child is legally alone, with no parent opponent. The best interest of the child standard applies, often misapplied when parents are present. Court-appointed special advocates signs for federal Title I VE funding, creating a financial incentive to maintain the child's abandoned status. Washington's criminal code lacks a statutory exception for Child Protective Services or Department of Children, Youth, and Families in kidnapping laws. This absence indicates that the legislature never intended these removals to be lawful against present parents. Typically, lawful state actions have explicit exceptions, suggesting this omission is significant, not an oversight. If CPS removals were truly lawful, criminal kidnapping laws would contain an explicit CPS exception. The absence of that exception suggests the legislature never contemplated these removals as a lawful exercise of state authority against a present parent. This argument follows standard statutory construction. When the legislature creates exceptions to criminal liability for lawful state actions, such as law enforcement arrests, those exceptions are written explicitly. The absence of a DCYF exception in kidnapping statutes is legally meaningful, not merely an oversight to be read around. RCW 13.34.055 states no person can have physical custody of a child in shelter care, suggesting the child is alone. However, children are taken from their parents' arms without an actual warrant. RCW 13.34.050 allows custody for abandoned children, but RCW 26.44.050 doesn't permit taking physical custody from present parents. The strongest arguments focus on statutory text, highlighting the 3-month abandonment rule for newborns and the custody distinctions. Mixed arguments, like no trial authorized, face established case law. The most challenging rely on absent statutory language, often countered by implied authority or practice, though not satisfying strict textualists. There seems to be a gap in RCW 13.34, originally for abandoned children, now broadly applied. We urge courts to adhere to statutory definitions, require warrants under RCW 26.21, and revisit cases affected by the Blake decision. Legislative clarity on reunification and parental rights is essential to prevent judicial overreach. Courts and DCYF should apply RCW 13.34 only in cases that meet the statutory definition of abandonment, not as a general child welfare intervention tool. The Washington legislature should explicitly address reunification, visitation, warrants, and the rights of present parents in any statute used to separate families, rather than leaving these critical matters to judicial interpretation. When removing a child from a present parent, the Uniform Child Custody Act, RCW 26.21, should govern, including its warrant requirements.
We are here for a review hearing, a 6-month review hearing. I've read the materials that were submitted to me, a report from the department, a statement from the mother, and I think I may have one other CASA report, yes. So I've read all those materials. Ms. McCoy, why don't you tee the hearing up for us?
Of course, Your Honor, thank you. A lot has transpired within the past couple of days. On Tuesday, May 16th, there was a screened-in intake reported concerning information to the department's social worker on how she did not feel safe and did not want to return home on Tuesday. The department did hold a FTDM yesterday with all parties present. From the department's perspective, it was a very successful meeting where Ms. Zayas did initially agree to engage in some services and put some services in place to help the family and more comfortable. Unfortunately, from emails we received today, Ms. Zayas does not want to move forward with those services. At this moment, the department is not requesting dismissal due to the screened-in intake and the open investigation. The CPS investigation is being conducted by the Keene East office, so in Bellevue, where a CPS social worker has already been assigned. The department is requesting for the trial to return home to continue, and that court supervision shall continue as well. Due to this very new intake, parties may want to amend the trial return home conditions, and if not agreed upon, parties would file a motion. As for the review hearing, the requested findings that the department is requesting today is that DCYF is making reasonable efforts and are in compliance. As for the mother, for findings of compliance, would request for those to be reserved. For findings of progress, we would say yes. The permanent plan is to return home to the mother still and to continue the trial return home. I will defer to Ms. Hollick. I know that was a lot of information and some information is brand new from our pleadings, but I will defer to the social worker if there's anything else you would like to add.
Yes, thank you. This is news, so it's not what I had reviewed in the materials. Ms. Hollick, is there anything you would like to add to Ms. McCoy's report?
Yes, Your Honor. Ms. Johnston-Hanks did submit a court report. She is asking for Ms. Zayas to be found not in compliance and not making progress. Return home with an alternative adoption. I think that Ms. Johnston-Hanks' report covers until the intake. I think on the health and safety visits, things were going pretty well. Attending school regularly, some follow-up that needs to occur with regard to her dental care. With regard to the new allegations, Your Honor, we did have a meeting about it yesterday. The allegations from the child are very concerning to the guardian ad litem, but I think taken in some context and explanation by Ms. Zayas.
I don't know what the allegations are. I never got any discovery, so I'm a lawyer and I don't have any discovery. You guys never gave me any discovery. I don't know what the allegations are, so you're making stuff up.
Hold on, Ms. Zayas.
Amaya told me they're lying, so they're making stuff up.
Hold on just a minute. Let Ms. Cowan finish, and then I want to hear from you.
And Your Honor, I'm not asking for any relief today. I'm just telling you that things have changed dramatically in 24 to 48 hours, and we think we're okay at the moment. But as far as the guardian ad litem goes, she would like some services in the home. Because the way Ms. Zayas explained the allegations, it was that was upset with her and wanted to punish her and basically texted Ms. Hollick that she's ready to be adopted. And I think given the explanation from Ms. Zayas that, I didn't give her the food she wanted. I didn't give her, I made her wear her coat. When there's an argument between Ms. Zayas, apparently,
why is she still talking? Isn't it my turn? Why is she still talking? Are we having court? What is this? Are we giving testimony today? What's this? Are we supposed to give a brief update and that's it? Because you're not doing all that. You're not being fair. So go ahead and be a, fair judge.
I want to hear from Ms. Cowan on behalf of.
We're not here for that, though.
Yes, we are. So
no, we're not. Said something brief. She just said something brief. Now you're letting her tell a story.
I'm letting her tell
I get to tell a story then,
Ms.
right?
Zayas, Ms. Zayas, I'm letting her tell her story, and then I will let you tell your story. but I do ask that you stop interrupting.
Your Honor, again, I'm sorry. I'm not asking for relief today. We're just trying to process the new information in context and write back with Ms. Zayas. And I will be continuing to talk to the guardian ad litem about how to, bring a motion to enforce or bring a motion to add conditions, bring a motion for order of contempt if conditions aren't followed. Is doing okay right now, except for the statements she made. So I think the guardian ad litem has to consider the statements in the overall context. So that's just, that's where we are today. I think the dismissal is going to be continued. That's our position. The other concerning thing is that Marcel, who is Ms. Zayas' adult son, is in the home or around. Said yesterday that he's in active use. So we are concerned about that.
So is your husband,
and I know that, and that's not new information. We know that he's been in the home, and I think Ms. Zayas is trying to care for him as well as.
Okay, so I get to make all these allegations too, right? Okay, so I'm ready whenever you are, because I got a big list for you.
Have you?
So, Your Honor, I know that the court is also leaving the bench, so I don't know how the court wants to handle any future motions or the next hearings. So we can address that at a later point. But I will defer to Ms. Johnston-Hanks if she has anything else to say. I think the relationship between the child and Ms. Zayas is still good, and there's still a bond, obviously. And I think the guardian ad litem is just weighing all of these pieces of information that are coming pretty fast. So.
Oh my God, what do we do? Poor kid. You guys are high. You can't cite RCW 1334 under the C option for this, okay? You can't, because I'm right here. So you can't say I'm not here. So I don't know what other option you're going to pick to try to force this. There's no other option because I didn't abuse her. So I'm wondering how you're going to force this and I sued Kristen and her homies last night. She's been sued. They've been sued again.
Ms. Zayas,
what? I'm allowed to talk too.
Yes, you are.
Just like she's allowed to talk.
I'd like to focus your attention, however, because extraneous
Why? Because
lawsuits,
I said I'm going to sue somebody, or I already sued somebody?
I don't care about those lawsuits. What I care is
You care about everything she says, though.
About your relationship with and what currently is going on.
She has no clue what they're talking about.
You don't know what they're talking about?
She doesn't know what they're talking about. I asked her last night. She said she has no idea what they're talking about.
Okay. Were you at the hearing yesterday or the meeting yesterday?
I don't know what hearing you're talking about.
Well,
no, I was not.
I was told there was a family treatment decision meeting yesterday after apparently made a complaint on Monday. So do you know about any of that?
Meetings. Nope. Sorry, I never went to any meeting.
And you weren't told about the complaint that was screened in on Monday, the 15th?
Yeah, I don't even know. They won't even tell me what the allegations are, and I'm my daughter's attorney, so I don't even know if that's even legal. I think I should at least know what the allegations are. I think that they're doing this to try to continue it, but what are they going to continue it under? I don't understand, because it can't be B or A. I didn't abandon her. I didn't abuse her. So what are you going to continue it under?
Well,
what's this dependency under? Because I'm not agreeing to anything. What prong are you? What prong? That's funny.
The issue
what
here.
What are you going to use?
The issue here is how the dependency is proceeding, and as I understood.
There is no dependency because I'm right here. You're saying I'm not there. That's what your dependency is based on. And I'm right here. So there is no dependency.
It's based on the
what?
Safety and well-being of Amaya in your care.
Prong C says I'm not there. So I'm right here. So then that doesn't count. So that,
and it sounds like things had been going very well. Although
they are going great.
You have not been compliant with the services that were ordered earlier.
I never have for years. So what's new?
That's right. But
so what's new?
Things were going well with your custody and care and her...
They're still going well. Just because they say that she did this and she did that, that means nothing. They wait 6 months and saying the same thing at every time they see her. They wait until the last day and say, oh, I said this. She's been saying the same thing every week and they never cared. They never did anything. She said the same thing every single week. Every time they came to visit, she told them she wanted to go be adopted by Amanda. They did not care. They walked away, they did their thing, and then they wait until now because they want to continue it and keep collecting funding and get sued, all of them repeatedly over and over again, and lose their jobs. That's what they want. Because RCW 1334 6C says that I'm not there. Learn the law. You probably don't know the law because you don't have a law degree, but this is the law.
Welcome to Your Rights Against Child Protective Services, the case law that protects you. This guide empowers pro se parents by exploring constitutional protections recognized by courts in cases of unlawful child removal by Child Protective Services. This is not legal advice. Remember, when you do decide to sue them, ask for oral argument. Because the clerk is best friends with CPS, she will alert them and dismiss your lawsuit. Make sure you hear the judge dismiss it. The district court clerks are reckless. Many of you know the person who created this video believes that CPS cannot prosecute parents under juvenile dependency. The juvenile is the defendant, which means they can't force parents to do anything. This video was created based on the court's view of CPS. Is it the correct view? Likely not, because these kids were not abandoned and most of these parents never agree to abandon them prior to their child being removed. Just thought I would drop that in there before we start. We'll explore constitutional protections under the 1st, 4th, and 14th Amendments, examine Child Protective Services overreach, and guide you on using case law in court. Who must prove what, and what evidence you need to build a winning record. Case law defining unlawful removal, false evidence, warrantless seizure, and shocks the conscience conduct. How to apply these cases when drafting your Section 1983 complaint and overcoming qualified immunity. Your rights as a parent are constitutionally protected. The 14th Amendment ensures due process, decision-making, and equal protection. The 4th Amendment guards against unreasonable searches, including child removal. The First Amendment protects your right to file grievances without retaliation and familial association. Use Section 1983 to sue state officials who violate these rights. Parents have a fundamental liberty interest in family association and privacy. Malik v. Arapahoe County Department of Social Services, 1999, underscores that Child Protective Services must follow due process before child removal. Cite this case early to highlight the constitutional right at stake. The shocks the conscience standard is crucial for challenging abusive government actions. Key cases like County of Sacramento v. Lewis and Miller highlight that only egregious conduct qualifies as arbitrary. Your complaint should detail facts showing the conduct was malicious or reckless, not just mistaken. Removal without investigation is unconstitutional. Child Protective Services must conduct a meaningful investigation before removing a child. Only in rare cases, where allegations are extremely severe and credible, can removal occur without prior investigation. Anonymous or uncorroborated tips do not meet this standard. Clearly allege what investigation occurred, evidence available, and the timeline of removal. Only if allegations are both extremely severe and independently credible can removal precede investigation. Anonymous or uncorroborated tips do not qualify. Only in rare circumstances can allegations of neglect be so severe or credible that an investigation into the allegations is not required for removal. Anonymous tips alone cannot justify child removal. In HRV, State Department of Human Resources, such tips lack probable cause. A caseworker relying on hearsay without evidence is unjustified, as seen in Hurlman v. Rice. Overheard information doesn't warrant removal. Mere danger possibility isn't exigent circumstances. The Fourth Amendment's protection against unreasonable searches and seizures applies to Child Protective Services investigations. Key cases like Walsh versus Erie County and Lenz versus Winburn affirm this, extending these rights to child neglect and abuse contexts. Always explicitly invoke the Fourth Amendment in complaints to ensure its application is recognized. Courts mandate that child removal must be justified from the start and proportionate to the situation. Without a warrant, court order, or true emergency, such seizures are typically unconstitutional, as established in CBV, City of Sonora, 9th Circuit, 2014. False information in civil rights cases nullifies immunity. In Young versus Biggers, defendants lose immunity if they provide false data for warrants. Malley versus Briggs states no qualified immunity without reasonable warrant basis. Social workers lose protection if they falsify court reports. Groh versus Ramirez highlights that a warrant doesn't protect officers lacking probable cause. The Supreme Court has set standards for parental rights and due process. Troxel versus Granville emphasizes parents' fundamental rights in child care decisions. Santos Guy versus Kramer requires clear evidence of unfitness for terminating parental rights. Quillowan versus Walcott mandates proof of unfitness beyond best interests analysis. These cases are crucial for due process claims. The right to family privacy is constitutionally protected, preventing state invasion without due process. Griswold versus Connecticut established this principle, emphasizing the mutual care and affection between parents and children. Duchesne versus Sugarman further extended this right to children, safeguarding their emotional bonds with parents from unwarranted dislocation. The right of families to stay together without state interference includes both parents' and children's rights. Duchesne versus Sugarman emphasizes this. Cage through Murphy versus Morgan highlights that social workers must avoid removals that harm a child's health. Such harm can form the basis of a legal claim. Filing a grievance, whether verbal or written, is protected under the First Amendment, as established in Entler versus Gregoire. To prove retaliation, demonstrate that the defendant's actions deterred your speech and were motivated by it. Document any escalation by Child Protective Services after a complaint or lawsuit threat to support your claim. You must show the defendant's conduct deterred or chilled your protected speech, and that deterrence was a substantial or motivating factor in their actions. Mendocino Yen VL Center v. Mendocino County, 9th Circuit, 1994. Qualified immunity protects Child Protective Services officials only when actions are objectively reasonable. Liability arises with excessive authority, such as removal without proper procedures or using false information. Reckless disregard suffices for liability, even without specific intent. Caballero versus City of Concord highlights these principles. In child removal cases, the plaintiff must prove no warrant exceptions applied, as seen in Lorez versus Holcomb. Conversely, Child Protective Services must demonstrate exigent circumstances existed per Hopkins versus Bombasino. Additionally, proving state action is crucial for a 14th Amendment claim, requiring the caseworker to have acted under color of law, as established in Brentwood Academy versus Tennessee Secondary School Athletic Association. At the summary judgment stage, the defendant must show that exigent circumstances actually existed. Hopkins versus Bombasino, 9th Circuit, 2009, proved that an exception to the warrant requirement, such as exigent circumstances or consent, did not apply at the time of removal. Lorez versus Holcomb, 9th Circuit, 1994, without proving state action, there is no 14th Amendment claim and no Section 1983 relief. The caseworker must have acted under color of law. Brentwood Academy v. TSSA. To build a strong complaint, first, clearly allege the constitutional right violated, naming the specific amendment and citing relevant cases. Document any lack of investigation by Child Protective Services, highlighting skipped steps. Directly challenge qualified immunity by showing false information or reckless conduct. Protect your right to complain against any Child Protective Services retaliation. Plead facts showing false information, reckless disregard, or conduct that shocks the conscience. Name the amendment, 4th, 14th, 1st, and cite the controlling case. Don't assume the court will infer it. Show what CPS knew when they knew it and what steps they skipped. Anonymous tips alone are never enough. If CPS retaliated after you filed a grievance or threatened legal action, that is an independent constitutional violation.